Before I start, could I acknowledge the original custodians of the land we're meeting on, pay my respects to their elders past, present and emerging. Around Australia, 34% of Australia is determined native title. About 21% of that is exclusive native title, about 12%, 13% is non-exclusive. And then there's another 27% of Australia subject to claim. In South Australia, there's 58% determined and 18% is under claim. So that's a little bit of just a picture. So what I did want to talk about was the Future Act regime, because I think it's just listening to what you're talking about, something that you might want to know about. The Section 29 notice begins our Future Act regime. So whenever the government wants to grant a tenement, be it an exploration licence or a mining lease, or then they need to give notice of their intention to grant. But we do actually have, you'll see there's here a little statement here called the expedited procedure. And if the government thinks that what they're granting, and it will, for example, an exploration licence is going to have little or no impact on native title, they'll say so in that notice. Now, different governments approach this differently. Some states, they actually filter and have a look and say, well, it really isn't likely to affect native title in that area. Some states apply it to absolutely every exploration licence. That's Western Australia. So we get a lot of expedited procedure statements in Section 29 notices in Western Australia. It's the government deciding whether or not to put that in their statement. Some governments will have different processes all around Australia. We get, as I said, a lot of expedited procedure statements in Western Australia, very few in Queensland, because they filter. And I don't know if they consult, but they seem to at least filter it. But what happens once that statement's in there, a native title party can object and say, no, we don't agree that it's going to have little or no impact on native title. So there's 4 months where a native title party can actually get on board and put in their objection. If there's no objection, then the grant can be made. But if there is an objection, what will normally happen, and we encourage this, is parties, we encourage them to go off and discuss the actual application and what's going to be involved. And often that, in fact, most times agreement is reached one way or the other. And the agreement that can be reached might be that it's okay to grant it, we've come to some agreement, or it might be we agree it should go to the right to negotiate. Sometimes a grantee party or the applicant will withdraw their application. There are different ways of dealing with it, but if that doesn't happen, it comes to the tribunal for the tribunal to decide whether or not there's going to be little or no impact. And the criteria we have to apply for that is to say, okay, the expedited procedure will apply if this grant of this tenement is not likely to interfere directly with community or social activities of the native title holders, not likely to interfere with areas or sites of particular significance, or not likely to involve major disturbance to land and waters. So that's an inquiry process. And at the end of that, the tribunal will say, okay, expedited procedure does apply because there will be little or no impact, and of course both parties will have the opportunity to make submissions. If that's the case, the government can go ahead with the grant. If the tribunal decides the expedited procedure does not apply, then we go to our right to negotiate, which I'm going to talk about shortly. But just to give you an idea, that's a kind of picture of the ratio of objections that have been lodged to Future Act processes that assert the expedited procedure over the last few years. A large percentage of those are Western Australia. So that's the kind of picture you get there. And then if you have a look at the use of the expedited procedure in Australia, you'll see what I mean about Western Australia being the most avid user of it. Queensland, a lot of mining activity, but doesn't use it anywhere near as much. And there was some in the Northern Territory in 2016, last year. But that, I think, was unusual for the Territory. They normally have a process of their own. They agree most things. They don't use the tribunal for much at all. Okay. So, Future Act determination applications. We have an application for a determination of native title under Section 35, sorry, not native title, an application for a determination as to whether or not a Future Act can be done under Section 35. But one of the key things is that we can't do anything unless there's been negotiation in good faith. And then we have criteria under Section 39. So the right to negotiate process goes like this. There's a Section 29 notice. As I said, no objection. Within 4 months you can do the Act. If there's an objection, this is the right to negotiate process, not the expedited procedure process. This is when you've gone through that, you've given your section, the government's given it Section 29 notice, it hasn't said it's going to be low impact, so there's a period for objection. If there's no objection, then the government can grant the tenement. If there is an objection, then there has to be a period of at least 6 months where the government party, the native title parties, and it could be parties, and the grantee party negotiate in good faith to try and reach the consent of the native title parties to the Act being done. At any time after 6 months, any party can make an application to the tribunal to make a determination as to whether the Act may be done, whether the Act may be done on conditions, or the tribunal might determine that the Act must not be done. When that comes to the tribunal, we still encourage parties to continue to negotiate, but the very first thing we have to inquire is, has there been negotiation in good faith? And if any party raises the issue of good faith, then we have to decide that as a preliminary issue, the preliminary question. So the first thing is, if any party other than the native title party hasn't negotiated in good faith, this is the way the Act works, then you have to go back and start negotiating again. You can't go on with your determination because we don't have the power to make it. And that means the grantee party and the government party. So there's a lot of law. There's law on what it means to negotiate in good faith. Really it means, I suppose in a nutshell, honestly, acting honestly and reasonably, and actually trying to reach agreement. So that's a key thing that we have in our inquiry process. When we get to the inquiry process, if there hasn't been agreement yet, we have 6 months under the Act in which to make a determination. And we must do that, or we need to write to the Minister and explain why we haven't made it within that time period. So they're the criteria. I'm not sure you can read them all, it's a bit small, but the first is the effect of the Act on the enjoyment of native title rights and interests, the effect of the Act on way, life, culture and traditions of the Aboriginal group, the effect on the development of social, cultural and economic structures, effect on freedom of access to the area and freedom to carry out activities of cultural significance, effect on any area of site of particular significance, the interest, opinions, wishes of the native title party, the economic significance of the Act to Australia, state, local area, also the Aboriginal people in the area, public interest, and any other relevant matter. So they're the criteria we have to have regard to. None of them has any particular weight over the other. It's completely a balancing act for us. So that gives you a little bit of a picture. They're the Future Act determination applications that we have made. Now they're the ones that haven't been agreed during the negotiation process. And when you look at the very large number of Section 29 notices that go out, and they're in the thousands, that means that there's a lot of agreement making going on. But this is what ends up coming to us for us to make a determination. And even then, quite a lot of those will reach agreement during that 6 month that it's before us for inquiry. So the Act itself does try to encourage agreement making in terms of all of these activities. The other part of our Act and our scheme, these are all agreements in relation to one particular tenement, and they're called Section 31 agreements. And so they would relate to a grant of one tenement. But you can actually do the Indigenous land use agreements, which I'm sure you're well aware of, which can cover a lot more than just the grant of one tenement. They're very flexible. They can cover large areas, and that's a bit of a picture of the Indigenous land use agreements around Australia. The purple are the body corporate agreements, and the green are the area agreements. So that gives a little bit of an idea of what's going on in terms of the larger agreement making. Those that are actually related to mining and energy, mining and resources, are the orange and the blue. So that gives you a little bit of a picture. A lot of the others are agreements that consent determinations that go along with consent determinations, or indeed local government agreements or pastoral ILUAs and the like. So thank you very much for inviting me.